It has to be to Assam. That's one point. It has to be prior to 1/1/66. It has to be from Bangladesh. And you have to be thereafter resident. Now, all these elements, I'm just suggesting to the court, because what is deeming? Deeming, according to us, is a basket of rights.
Just there has to be a machinery.
Yeah. No, so I'll come to that. It's a basket of rights. Citizenship is a basket of rights. And that basket of rights includes political rights, it includes civil rights, it may include social rights, it may include economic rights. This is a very important concept because that will also tie into your some tentative observations were made of does proportionality have any role in this, and we'll try and suggest some solution.
What the chief is saying is this.
Yeah.
You are right. Now it is ultimately for the individual to have his own view of satisfaction of these four criteria.
Yeah.
Now
there's also the
merely because subsection 2 does not speak about it.
Yeah.
The question is, will that take away the power of the state government,
right,
to go into that issue and satisfy itself whether A or B satisfy this?
So may I answer that?
Yeah.
I'll answer that straight away.
Okay.
My respectful submission is that and there'll be some guidance from some case law, which I'll place presently. But once you specify criteria, you must, in the facts and circumstances of this case and having regard to the nature of this provision, have a machinery to determine those criteria.
But see, a deeming fiction is provided by the Constitution itself in Article 7. The Constitution itself provides for a deeming grant of citizenship in Article 6.
Yes.
There is no machinery in Article 6. Of course, you can't challenge an original provision of the Constitution that it is a violator of the. See, Article 6 also says,
right.
So, notwithstanding, etc.,
Yeah.
shall be deemed to be a citizen of India at the commencement of the Constitution.
I accept that.
So, even the Constitution.
But that is a starting provision, Milord. Someone had to be a citizen of India. So there was a cut-off date which was prescribed and there were provisions which were made. That's very different according to us.
But if somebody were to claim the benefit of Article 6 citizenship, then the question as to whether he or she satisfies.
Should there be a contest?
Right. That can be gone into.
So may I answer that in this manner? I accept the provision, I accept the position that you may have certain circumstances, such as at the inception of the Constitution or at the starting of the Constitution, when you may not require to have a case-by-case determination insofar as individuals are concerned. However, the nature of 6A2, and I'm not putting it any higher than that, 6A2, by prescribing objective criteria, required, according to us, a machinery to ascertain those objective criteria in individual cases. It can't be just as a defense mechanism when someone wants to take action against you that it happens. Because you're conferring a basket of rights, including political rights and the full range of rights. So that, my lords, is my respectful submission. And according to me, our submission is that this is fatal as far as this. Because otherwise it really amounts to saying, now I'll just flip it around. Supposing they provided no criteria. Ultimately, that's what it means. If you are not providing a machinery, it is a criteria-less citizenship with a date of 1st January 66, because nobody is required to go through any evaluation process at all. That's exactly as the Chief Justice correctly observed, that probably happened at the inception of the Constitution, where there was a presumption that everybody who was there on or before a particular date is deemed to be the citizen of India. So that's okay there. But is it now okay here is the question for your lordships to consider. Yeah. Right. Yeah. That, my lords, that permit system, etc., has been explained to your lordships. So these, my lords, are my submissions as far as 6.2 is concerned. Now I want to go to 6A3. I'm sorry.
6A3.
Yeah. Now on 6A3 again, first point, no time limit. I think that's common ground. Now, if no time limit is provided for working out this section, according to us, the section itself is vulnerable, and I have premised this submission on the basis that we suggested a few expressions that the provision remains on the statute book and continues to act as a beacon indefinitely. It's like a magnet which attracts people to Assam with all the consequences as far as illegal migrants are concerned. And therefore, in our respectful submission, this is a fatal element to it, namely that there is no time limit which is prescribed within which this process is to be completed. It can be done tomorrow as well. That's open-ended, and that's very, very dangerous and wrong and illegal according to us. So this is our next respectful submission. Now, Malad, I'm focusing on another concept. And the concept which I'm now focusing on is person ordinarily resident in Assam.
This is under the 6A3 challenge, right?
Yes, but it's actually, it will span both, because that same expression is used here. But I'll just make the point. Now, if we go to 6A1, you will find, if you just have a look at 6A1, you will find there's a definition as far as Assam is concerned: detected to be a foreigner, specified territory, deemed to be a person deemed to be of Indian origin, and deemed to have been detected. Your Lordship sees that? The expressions which are defined. Person ordinarily resident in Assam is not defined. Now, this is very, very important for my purposes, because this is really the entire fulcrum on which both the sections and the subsections and the entire scheme operates. And this was my primary grievance, if Your Lordship recalls in the opening. This whole business of making it persons ordinarily resident in India and compelling everyone to remain there. Well, that's one aspect. But now let's focus on 6A3. Now, I ask myself, if you have certain statutes like, say, FEMA, Income Tax Act, you have notions of residency defined or linked to the number of days. Maybe 182 days, it may be something more, but you have to have a clear definition. It cannot suffer from this type of vagueness, undefined expression. Key core provision of resident in India, ordinarily resident in India, person ordinarily resident in Assam. I'm sorry, what does that mean? Is it 1 week? Is it 5 weeks? Is it 6 months? Is it 5 years? Is it 2 years? No yardstick at all provided. And this, according to us, cuts across both subsections. It leaves it completely vague. And in our respectful submission, if we are right, unconstitutionally vague. You see, the vice of extreme vagueness in a situation for a core concept such as this, what does it leave it? What is the guidance given to a foreigners tribunal or anyone else? What is ordinary? This is a question I ask myself. Now, in this regard, actually in both respects, machinery, absence of machinery, as well as for vagueness, we have some guidance to be obtained from a decision of Your Lordships. Which is it? Yes, this, my Lords, I'll just give you the citation very quickly. This is a judgment, yes, of a constitution bench. I'll give you the citation. 69-2 SCC 166. Yeah. Harakchand Ratnachand Banthia versus Union of India. We'll just request the court master to put it up. 69-2 SCC 166. Now, this had to do, and the relevant paragraph I should just indicate is para 21, in the context of renewal of licenses. At page 1, I think it may be at page 1, para 21. It begins with, we now come to section 20. Yes. So I'll just place this, it spans both issues. And it's self-explanatory when I read the para. We now come to section 27 of the Act, which relates to licensing of dealers. It was stated on behalf of the petitioners that the conditions imposed by subsection 6 of section 27 for the grant or renewal of licenses are uncertain, vague, and unintelligible, and consequently wide and unfettered power was conferred upon the statutory authorities in the matter of grant of renewal of license. In our opinion, the contention is well-founded and must be accepted as correct. Section 27(6)(a) states that in the matter of issue of renewal of license, the administrator shall have regard to the number of dealers existing in the region in which the applicant intends to carry on business as a dealer. But the word region is nowhere defined in the Act. Similarly, sections 27(6)(b) requires the administrator to have regard to the anticipated demand as estimated by him for ornaments in that region. The expression anticipated demand is a vague expression which is not capable of objective assessment and is bound to lead to a great deal of uncertainty. Similarly, the expression suitability of the applicant in 27(6)(e) and public interest in 27(6)(g) do not provide any objective standard or norm of guidance. For these reasons, it must be held that clauses so-and-so impose unreasonable restrictions on the fundamental right of the petitioners to carry on their trade and are constitutionally invalid. It was also contended that there was no reason why the condition for renewal of license should be rigorous as the condition for initial grant of license. The requirement of strict condition for the renewal of license renders the entire future of the business of dealers uncertain and subjects it to caprice and arbitrary will of the administrative authorities. There is justification for this argument, and the requirement of Section 26 of the Act imposing the same conditions for the renewal of license as for the initial grant appears to be unreasonable. In our opinion, so-and-so are inextricably bound up with the other clauses in Section 27(6) and form part of a single scheme. The result is that clauses so-and-so are not severable and the entire Section 27(6) must be held invalid. 27(2)(d) of the Act states that the valid license issued by the administrator may contain such conditions, limitations and restrictions as the administrator may think fit to impose, and different conditions, limitations or restrictions may be imposed on different classes of dealers. On the face of it, this subsection confers such wide and vague power upon the administrator that it is difficult to limit its scope. In our opinion, 27(2)(d) of the Act must be struck down as unreasonable restriction on the fundamental right of the petitioners to carry on business. It appears, however, to us that if Section 27(2)(d) and 27(6), etc. are invalid, the licensing scheme contemplated in the rest of 27 cannot be worked. It is therefore necessary for Parliament to enact fresh legislation, etc. So this is important in the context of vagueness, which your Lordship... Are we going there directly? Yeah. Yes. So this, my lords, I think, at least we feel that this is persuasive on the point that when you have such key concepts which remain completely undefined and open-ended, we are left guessing as to what is the exact contour or parameter of persons, my lords, who are resident, shall be ordinarily resident in India, in Assam, I'm sorry, since the dates of entry, etc. So this is too crucial a concept without any parameter, anything laid out. So anyway, I'm done now with this point. Yes. Now this I should, yes, your Lordship may just note it, that this was followed to strike down 66A in, I'll give you the citation, Shreya Singhal versus Union of India. That's of course a two-judge bench, my lords. 2015, volume 5 SCC, page 1, at paragraphs 55 to 68 and 85, two learned judges. And in Shaira Bano versus Union of India, this aspect is now regarded as a facet of manifest arbitrariness. In Justice Nariman's judgment, 2017, 9 SCC, page 1, paragraph 101. That is, my lords, at index number 163 of volume 5 before your lordship. Shaira Bano is there. So now this is one aspect. Now there's one other parallel, one other aspect which I'll just, since we are on this machinery aspect, I'll just indicate. We have the advantage of a constitution bench judgment in state of Madhya Pradesh versus Baldev Prasad. The citation is 61, 1 SCR 970. And from the SCC print, it is paragraphs 8 and 9 that are relevant. Oh, okay, we'll try and get that. It's the paragraph beginning, the section does not provide that. Yeah, further down. Here. Oops. Accidentally. Above this? Yes, just above. Yes, here. The section does not, your lordship has that. Now, I'll just explain this. So this was in the context of the Gunda Act. And the provision was struck down by the High Court, upheld by the Supreme Court, because the definitions were just so completely vague. Now, just 2 paragraphs. The section does not provide that the district magistrate must first come to a decision that the person against whom he proposes to take action is a Gunda and gives him no guidance or assistance in the said matter. It is true that under Section 4, a Gunda is entitled to have an opportunity to be heard after he is given a copy of the grounds on which the order is proposed to be made against him. But there is no doubt at all, that all the Gunda is entitled to show in response to the notice is to challenge the correctness of the grounds alleged against him. The inquiry does not contemplate an investigation into the question as to whether a person is a Gunda or not. The position, therefore, is that the district magistrate can proceed against a person without being required to come to a formal decision as to whether the said person is a Gunda or not, and in any event, no opportunity is intended to be given to the person to show cause he is not a Gunda. The failure of the section to make a provision in that behalf undoubtedly constitutes a serious infirmity in the scheme. So what we are is trying to draw sustenance in terms of our argument is that providing a machinery for determining and not just issuing a show cause notice to Gunda, you can't, this converse point, namely that, oh, it might be weeded out in a process if and when someone is detected, is not enough. There ought to be, in our respectful submission, I'm sorry.
For those who take the benefit of subsection 3, there is a machinery.
For 3, there is a machinery.
There is a machinery by the explanation. So when
yes,
you apply
no, there's no doubt about that.
Yeah.
There's no doubt about
There's no machinery for
you're right,
subsection 2.
This is my machinery argument is confined only insofar as
subsection 2
is concerned, and also to the extent that if you haven't defined a person who is ordinarily resident in Assam, I mean, then what is the inquiry going to be? It's just completely vague. What machinery can the machinery do also? This is such a crucial concept, my lord. It has to be in some days, numbers, something has to be there. Ordinary resident, it's just otherwise completely.
You have artificial definitions for fiscal legislation, like income tax.
Right.
180 days.
Yes, right.
For FEMA,
right.
Whatever, 270 days.
Yeah.
But these are not, in that sense, fiscal enactments. For the fiscal enactments, it normally will have a very precise definition.
Yeah.
You're conferring citizenship.
Yeah.
So ordinary resident is not, it's not a term of art. It has the ordinary connotation. Somebody who...
But how many days? I ask myself.
It won't be, say, ordinary residence for 2 days or ordinary residence for 3 days.
But what is it, 6 months?
You're right. There is no precise definition.
Frankly, Malaj, the law is actually to the contrary. If you with an intention move, so for example, someone like me sort of moved cities and came to Delhi. If a person moves to Delhi and even on day 5, if I've intended to move to Delhi, I would then probably have to describe myself as resident if I pack my bags, etc. at day 2.
Intention to reside.
Yes, but here, therefore, you have a situation, Malaj, please, this is in the context of illegal migrants, Malaj. It's not an ordinary person translocating within the country, etc. And so, having regard to that factual matrix, absent any criteria, any guidance, I believe it is constitutionally infirm in terms of an absence of any definition. So, Manoj, I am now done with this particular aspect as well. Now, I go to my next point. Now, here I wish to draw support from the joint communique. So, I'll just state the point. First, the point is this. The point is neither the... Sorry, one more point, Manoj, in that notion of ordinarily resident in Assam. I'll just make that point and then I'll move to the next one. This is not a concept which we found embedded anywhere, either in the Assam Accord or indeed in the communique. I'll just state that point. So that has no basis at all. That's a creation and a construct. There's no historical basis. There is no commitment in terms of international obligations or anything like that as far as this notion of ordinarily resident in Assam is concerned. Now, Manoj, I'm on the communique. Now, would your lordship please, sorry. Yes, your lordships will find that at serial number 4A, page 9398.
Volume?
And it's at serial number 94.
Volume?
4A. So I'll just state my points quickly on this communique.
4A, page 94.
Yeah. The page is 9398. Page 9398 of volume 4A.
Yeah.
Your Lordships have the communique.
Yes.
So if you have page 9398, to just see the second paragraph of the communique, starting with the words during his stay. During his stay, the Prime Minister of Bangladesh addressed a mammoth gathering of people of Calcutta. He expressed gratitude on behalf of the government and people of Bangladesh to the government and people of India, especially to the neighboring states of West Bengal, Tripura, Meghalaya, and Assam for the hospitality and assistance given to the millions of Bangladesh citizens and for the moral and material support given by the government and the people of India to the struggle for liberation. And then your Lordships will see a further reference to that date, 25th March 1971. That's towards the foot. The Prime Minister of Bangladesh solemnly reaffirmed his resolve to ensure by every means the return of all the refugees who have taken shelter in India since 25th March 1971 and to strive, etc., etc. So I make 2 points. The first point I wish to make is, this is not specific to Assam. Well, let's be very clear on that. This communique doesn't single out Assam at all. And I make a second point, which is, in fact, the communique treats the neighboring states of West Bengal, Tripura, Meghalaya, and Assam as a single set of bordering states for which the Prime Minister of Bangladesh also accords his great thanks and extends his thanks to the people of these states. So I believe this supports our submissions in 2 respects. First, this is no justification for singling out Assam. And second, in terms of what was recognized as the impact even then was all these border states. And therefore, this amounts to invidious discrimination and it amounts to an object which is itself by its very nature discriminatory. Now I want to just, there are several other points, but I'm just going point-wise. But I want to just leave a thought with you and then I'll come back to it. Please consider, if you consider it appropriate, and I'll deal with this in the context, other submissions. I'll just state the point and then cite the decision later. I believe this provision ought to be struck down entirely. That's my case. But please contemplate a prospective invalidation. Think about, I'm sure your Lordships will think about it the moment we make a submission in that regard. But I'm just planting the seed at this point of time. Look, it was mentioned correctly by, I don't know what correctly, but the Solicitor General at least at one point reacted to the observations made by the bench. I'm just saying it was a reaction. Maybe this is in the nature of a transitory provision, etc. But I'm not holding anyone to that particular expression. But surely, when you have no time which is prescribed at all for when you can take advantage of this, and if it were for some historic purpose from 66 to 71, surely it should not continue on the statute book and become a license and become an opportunity, a fertile ground for all sorts of local industries with regard to documentation and things of that sort, and remain on the statute book and remain on an endless beacon only to the state of Assam. So anyway, I've just made that point with regard to this. So I now come to my next submission. It really builds on the point regarding the communique. Territorial classifications we accept are valid classifications. That is a valid method for the legislature to certainly go about its job. We don't question that at all. The issue is it a valid classification here when the problem was for all the border states? when the communique recognized all the border states, when the affidavits which have been filed by the union government also record and their submissions record and accept that this is a huge problem in other states as well, which are just our neighbors, then the question I ask myself is, surely this is a case of impermissible and a discriminatory object of itself, singling out Assam for this. And when it is combined with the notion of ordinarily resident in Assam and continues to be ordinarily resident in Assam, it has impacts across generations and across decades. Yeah. Now I come to the next point. So I won't take you there, but the Solicitor General correctly went through his written submissions and he pointed out 6 sets of provisions in our constitution itself, which are specific to Assam. So I'll just comment on them because that was a point which was raised. The provisions which are special to Assam in our constitution are in this regard. First, with regard to autonomy and greater autonomy to certain areas, including 6th schedule. That's one type. Second, it is with respect to grants being made by the central government in lieu of export duty on jute. So again, it's something beneficial. Third, it's in respect of general grants in aid to Assam, because there are parts of the country which are found to be necessitating or requiring a leg up. Fourth, there are special provisions by the GST Council for Assam and a number of other enumerated states. There are 6 or 7 states which the Solicitor General fairly placed before you. So it's a group of states where it was felt that the GST Council, etc., has to have special regard with regard to Assam. Then it's with respect to provisions for reservations of scheduled castes and scheduled tribes. And the other special provision is for tribal administration. So broadly, these are special provisions inuring to the benefit of the citizenry of Assam, the people of Assam, and the state of Assam. They are not provisions where you set out one territory and then discriminate in it. When I say discriminate, what I mean is, your lordships have followed. I mean, I'm not saying there was some animus against the state of Assam, not that way. What we are suggesting to the court is, by singling Assam out and then coupling it with ordinarily resident for all times, I mean, it's really a death blow, or it's terrible as far as the demographic and future impacts are concerned. So, territorial classification we accept. All the examples given are beneficent for advantages, for certain social good and uplift. I don't believe the present statute fulfills any of those requirements insofar as the citizens of Assam are concerned. Now we have no, yes, I would respectfully submit, there is no instance of any what I would describe as hostile discrimination. These are all beneficent classifications for Assam. There is no case, at least as which we could find, or no situation where Assam has been singled out for the purposes of something harsh or something which is disadvantageous. I'll say disadvantageous. Now I come to the next point. And the next point is really in terms of, now the reality is that this 6A is only with respect to Assam. So I'm just stating the point. I believe this by itself and nothing further requires heightened scrutiny or strict scrutiny and not the relaxed scrutiny standard which was commended by the Attorney General. I will just put it at that. Now please, sorry. Yes, no problem. Later. Statelessness. Yeah. Now, my lords, I'm on my next point. Now, here, please consider as an alternative submission on our part an appropriate declaration, strictly in the alternative from my standpoint, a declaration that the impugned provision section 6A be declared prospectively to be invalid. And here, I'll just give you the citation. The judgment that we are relying upon is Somaiya Organics. Okay. 2001, Volume 5, SCC 519. The relevant paragraphs are 23 to 27. Sorry, 20, my mistake, 23 to 37. I'll just read 37, Your Lordship. I mean, if it's there, well and good. Otherwise, 37. Okay. Yes. Nevertheless, an enacted law without legislative competence remains on the statute book till a court of competent jurisdiction adjudicates thereon and declares it to be void. When the court declares it to be void, it is only then that it can be said to be, it is non-est for all purposes. In synthetics and chemicals, the invalidity of the provisions was a declaration under Article 141 of the Constitution. It was for doing complete justice that the court, in exercise of jurisdiction under Article 142, molded the relief in such a way as to give effect to the declaration prospectively. It is not possible to accept that such an order of prospective overruling is contrary to law. An invalid law has to be held to be, and has not been held to be valid. All that has happened is that the declaration of invalidity of the legislation was directed to take effect from a future date. So this might be, I mean, just if we are wrong with respect to our primary submission, but you feel, or rather, if we are right on the primary submission, but Your Lordship feels that still there is some molding which is required to be done, then you may consider this. But according to us, it is really unfair to have this continuing on the statute book, because it's not just a one-time issue. It's an abiding impact which continues across generations. Now I come to my next point, because I understood a submission to be made that with regard to culture, there has been no explanation in either the pleadings or in any of our documents as to what it is, etc. So I'm just giving you the paragraph numbers and the page numbers, and I'll just summarize our case. In writ petition 876 of 2014, which Your Lordship will find at volume 3, volume 3, the averments as far as culture are concerned in great detail are from paragraphs 21 to 34 of the petition. And it's at pages 3010 to 3020. So we've given definitions of culture, international obligations for present. Sorry. Just a minute. Yes, yes. For 6A2. Yes, that's a, yeah. Yes, it does. Yeah. Yeah. Right. No, but can I just tell you, at this distance, so yeah. So may I just respond to that? So I'll just respond to that. The question being put, sorry. If I have to 15 pounds. Yeah.
Persons who would have not have been included. But still it will open to them to contend that we were there before 66.
Yeah. So I'll
Either
just
that's
answer. but the
factually that's
question-
also possible.
Yeah. The question to being, as I understand it, is that is it too late in the day to provide a machinery insofar as 682 is concerned? That's one, I think, one part of the question. In my respectful submission, at this distance of time, which is 37, 38 years after 1985, that's why we waited to see how are they going to place their case as far as machinery, etc. is concerned. But nobody even suggests that there's a machinery under 682.
Actually,
So I would, sorry.
there's a little bit of a policy determination by Parliament. I think what Parliament seems to have done was that they said prior to 1966,
Yeah.
they gave a very liberalized regime for deeming citizenship. After 66 and
It's the
before
same four
70
criteria.
But between 60, you're right, same criteria.
Same criteria.
But with the addition for 66 to 71
Deem.
of registration. No registration.
But that's included, Manoj. That's, please see that.
There is no
expression.
registration requirement for prior to 66.
Sorry? Registration under 63. Yes.
So therefore, for those who
that-
came in between 66 to 71, they had one specific criterion, namely that you must have been detected as a foreigner. That is, it's like an amnesty. That, first you are detected as a foreigner. If you are not detected as a foreigner, you don't get the benefit. After you're detected as a foreigner, you have to then register. If you have registered, then you get citizenship. That's the scheme for 66 to
Actually,
70.
that is how we understand it as well.
That's right.
Because it was suggested, and just to add to that,
Yeah.
we didn't find any method by which you can make a self-declaration.
You have to be detected as
It
a
has to be detected.
Now, prior to 66, I think there seems to be some sort of a more, should we say, a more relaxed regime which was applied by
What does
Parliament.
it mean?
On the basis that, these were things which happened in the past. They are not going to go out of India. You don't want them to be stateless. They have assimilated for all intents and purposes, because prior to 66 means that 19 years had elapsed even when the law was brought into force. Parliament felt that, all right, now what has happened in the past, let's now freeze it at that.
Well, I would respectfully submit that would, sorry.
Compared to 66 or
Yeah. So just responding to the point, I would be a little more generous to Parliament. In the sense, I would suggest that Parliament is certainly providing criteria which are objective. So what I'm suggesting to the court is that I believe it would be correct to interpret this statute as saying that Parliament intended exactly what it mentioned. It didn't want to just hand over citizenships XYZ.
There are those conditions even there.
There are criteria which are there. Now, if you have criteria which are there, there ought to be a machinery. So what your lordship is saying, there's not even a census. It's not even after this act comes into force that there is a count that at least we are freezing everybody on this day.
There would be a
Not even that.
There would be a machinery under the foreigners order.
No, there's nothing, my lord. Nothing happened after 1985. It's just, we specify so that nobody can really object and say it's criteria less. And then we have no machinery, so it becomes criteria less. And then there's a distance of time, so therefore an argument is advanced that delay and later. So I think we should be. Yeah, so I'm done with that. Now, my lord, yes, no, so I'm just making the point. So now on culture, I was on that aspect. Culture. I've given you the pages where we have detailed, we've cited, my lord, various international covenants, etc., with regard to the protection of culture. And based on the census report, because the studies which we placed in our opening were based on the census figures. So 4 impacts: language, religion, land holding, and number 4, self-governance. Because if you're taking away vote, it's a right according to our self-governance. Organizing yourself in a community is all a very, very important aspect of culture. And what is happening here is there is an enormous undermining of the local community by, I will use the expression, non-citizens. So that's the cultural impact which we have, which we believe we have been able to satisfactorily project. None of this has been contested at all. Now I come on to the point, next point, which is with regard to proportionality and the basket of rights. Now, citizenship, as we understand it, I indicated that earlier, is a full-fledged basket of rights recognized under the Constitution, recognized under statutes. One can understand, there are subordinate rights. Those subordinate rights might involve an exclusion of political rights. It might involve an exclusion of certain economic rights.
What is that point? Subordination?
Sorry?
What is the second point?
No, so I'm just suggesting to the court that you have a full basket of rights.
Yes,
that's one. That's citizenship. But there can be situations. So, for example, let me just give you an example. International humanitarian law requires, there are minimum standards under international humanitarian law. You have to provide that. You can't, but that is short insofar as of citizenship. So, the proportionate response which would be in a situation such as this, if people have come from 1966 or earlier than 66, or because of certain situations and exigencies, such as facing deprivation or facing much more hostile circumstances, then certain minimum international human rights, humanitarian law standards can certainly and ought to be extended. But that is short of citizenship. And therefore, in our respectful submission, 6A fails to narrowly tailor benefits to non-citizens. It is completely disproportionate in what it grants and gives without any meaningful scrutiny. And so the expression used, live and let live, is perhaps consistent with international humanitarian law in the context of illegal migrants, but there is no requirement of conferring citizenship. That is something much higher. And this provision, in doing so, perhaps exceeds permissible limits. Now I go to my next point. So I will just come to statelessness, but just have a look at one provision which was read, which is the Foreigners Act. Sorry, but there are two sections I want to read. First, please just have a look at the Foreigners Act. Section 3, subsection, section 3, it is at page 386 of volume 4, serial number 6. There are just two statutes I want to touch on. Your Lordships have the Foreigners Act 1946, because this was a question.
Mr. Diwan, page is volume 3, page?
386, volume 4, 386. So I'm going to just read these, just read the section. So your Lordships will see what can the central government do, or what is it required to do elsewhere in the country. Your Lordships have Foreigners Act 1946.
Yes.
So if we see section 3 directly, I'll just read this. 3(1), power to make orders. The central government may by order make provision, either generally or in respect to all foreigners, or with respect to any particular foreigner, or any prescribed class or description of foreigner, for prohibiting, regulating, or restricting the entry of foreigners into India, or their departure therefrom, or the presence of continued presence therein. In particular, and without prejudice to the generality of the foregoing power, orders may be made under this section that may provide that the foreigner, A, shall not enter India, or shall enter India only at such times and by such routes. B, shall not depart from India, or shall depart only at such time and by such route from such port. Shall not remain in India or in any prescribed areas therein. Shall, if he has been required by order under this section not to remain in India, meet from any resources at his disposal the cost of removal from India. D, shall remove himself to and remain in such area in India as may be prescribed. Shall comply with the conditions as may be prescribed or specified, requiring him to reside in a particular place, imposing any restrictions on his movement, requiring him to furnish such proof of his identity and to report to such particulars to such authority, requiring him to allow his photograph and finger impressions to be taken, requiring him to submit himself to such medical examination, prohibiting him from association with persons, prohibiting him from engaging in activities of a prescribed or specified description, prohibiting him from using or possessing described or specified articles, otherwise regulating the conduct in any particulars as may be prescribed, shall enter into a bond, etc., shall be arrested and detained or confined, and may make provisions for any matter which is or may be prescribed, and for such incidental and supplementary matters. So very wide. Now this is the regime which applies across India for foreigners. This is their power which they have. And please see subsection 3. Any authority prescribed in this behalf may, with respect to any particular foreigner, make orders under clauses E, F of subsection 2, which, as your Lordships have seen, includes the removal, requiring a person to reside in a particular place, etc., and to enter into a bond, etc. So now this is the national regime. So they have these powers, and I think the purpose of this section is also to draw the distinction between citizens on the one hand and foreigners on the other hand. So there's a divide, and there is a huge gap, therefore, in lifting up to a citizen. Now, please see the other provision which was read to your Lordships is the Immigrants Expulsion from Assam Act 1950. Now, look at this statute. It's at page 424 of volume 4, and it's at serial number 10. Same volume.
Immigrants expulsion from Assam.
1950. The Immigrants Expulsion from Assam Act 1950, which was placed in court.
Page? What page should that be?
424. Volume 4, page 424. Now see the parliamentary mandate here. An act to provide for the expulsion of certain immigrants from Assam, be it enacted by Parliament, short title, the act may be called the Immigrants Expulsion from Assam Act 1950. It extends to the whole of India. Power to order expulsion of certain immigrants. If the central government is of the opinion that any person or class of persons having been ordinarily resident in any place outside India has or have, whether before or after the commencement of this act, come into Assam, and that the stay of such person or class of persons in Assam is detrimental to the interests of the general public of India or any section thereof, or any scheduled tribe in Assam, the central government may by order, A, direct such person or class of persons to remove himself or themselves from India or Assam within such time and by such route as may be specified, give such further directions in this regard to his removal or the removal from India or Assam as it may consider necessary or expedient. And then the proviso, provided that nothing in this section shall apply to any person who, on account of civil disturbance or fear of such disturbance in any area now forming part of Pakistan, has been displaced from or has left his place of residence in such area and has been subsequently residing in Assam. So I'll just make 2 or 3 submissions. First, where the expression in section 2 is the central government may by order direct the person to remove himself, we would respectfully submit this is a power coupled with duty. That's one point I want to make. So the whole emphasis is that you have a parliamentary statute which is extant for expulsion of people from here. And on the same hand, how do you balance that with section 6A and this open-ended no time limit provision which continues to act as a beacon? So the two really don't stay or can't really sit side by side. And here, if we are correct that this is the act which really should be worked and its main purpose is expulsion, then I would respectfully submit that as far as the proviso is concerned, it has to be given its plain meaning, but it's a narrow exception to the general rule. It's a narrow exception insofar as the general rule is concerned. Yes, and this again, my lords, there's no question, of course, here of conferral of any citizenship. Now, my lords, I just want to point out one part with regard to one other element, and this is in our writ petition. I'll just give you the page number. It is page 3044, volume 3. Now, I am just mentioning this because it came up in the course of your lordship's observations, etc. There's an extract here from Dr. Namrata Goswami, who's an associate fellow at the Institute of Defense Studies and Analysis, New Delhi. And she has written a paper or a study. And there is a quotation here, which is important from a facet which your lordships raised, which is economics. Because the state has limited economic resources, and what is happening as a result of illegal migrants is that there are manifold economic impacts which are recognized here. So the labor law, the labor rates, etc., go down. And the result is that local people don't get as much of a living as they might otherwise. Then there are beneficent schemes which the government of India rolls out, and those resources also get drawn up by persons who ordinarily would not be entitled to it. Now, my lords, I go to my next point, and the next point is with respect to this notion of statelessness. Now, I'll just make 3 or 4 points on statelessness. I gave it. No? Oh, sorry, the whole document is also available. I have to give it.
That issue, statelessness, doesn't arise here, my lord. It arises in somewhere else.
No, but my lord, they've argued on statelessness, and that has weighed heavily with your lordships. That I want to just address your lordships on statelessness. I'll just make 4 points or 5 points. First point.
There are other petitions pending on this, my lord. Therefore, I am cautioning my learned friend as a good friend, my lord, that let him not touch this issue. My lord. Nobody has raised it.
No, but it's a concern which your lordship is. The argument made is that if you strike down 6A, it will result in statelessness. I'm only meeting that argument and nothing further. I'm not going beyond that. The argument of the respondents was that please don't strike down section 6A. That's how I understood the argument. We will be rendered stateless and there'll be... So I'm just answering that. First point. This argument of statelessness is completely unjustified. And the reason we say so is because, number one, what is the regime which applies across the country other than Assam? Is the question I ask myself. The very same regime which applies across the country doesn't result in statelessness, will apply to Assam if we are correct and this provision is struck down. That's number one. Number two, nobody is asking for consequential reliefs in some summary manner. We are only seeking today a suitable and appropriate declaration of the law. The declaration of the law will not result in, by itself, it will just state what the correct, it will clarify the correct position in law. What consequential provisions are to be, action is to be taken will follow from that once we have the advantage of your lordship's ruling. But to hold up statelessness and say that, oh, if 6A goes everything, I don't believe that there is any justification at all for that. Now, this takes me to the latest affidavit they have filed. Now, please just go to that affidavit. The new affidavit. Please go to page 2, paragraph 4. I'll just focus on a couple of paragraphs. You may, sorry. Your lordships have the affidavit?
Yes.
So you may just consider on the 7th December order, I think in clause Roman 1, perhaps it should be 6A3. You may, I mean, if you find that as an error, then that just may be.
Mr. Devan, after this affidavit, you will wrap up because then we can use
Yes. No, I'm wrapping up. Yeah. So I'll just make 2 points over or 3 points. So that correction if you want. Now just see para 4. That with reference to query 1, namely the number of persons to whom citizenship has been granted under the proviso to 6A, I think it should be 3, namely persons who came to Assam between 66 and 71, it's humbly submitted 17,861. Your lordship has that figure. And the next figure is, which is that the foreigner, that with reference to the query, how many persons have been detected to be foreigners by an order of the Foreigners Tribunal under the Foreigners so-and-so order 64 between 66 and 71, the answer is 32,381. So the first issue, which I'm just stating the point, is what happened with regard to 32,381 less 17,861. So that works out to 14,520 persons. So they must inform the court as to what is the action which has been taken in respect of these 14,520 persons, because these people are found not to be entitled to any right even under 6A3. So I would respectfully submit. So this is one important point which your lordships will consider. What is the action taken with regard to that? And then please see 6AA, para 6A. Illegal migrants enter into the country without valid travel documents in a clandestine and surreptitious manner. The detection, detention and deportation of such illegally staying foreign nationals is complex and an ongoing process. So when your lordships asked them for the estimated flow, this was the answer. Now the bottom line is, there is no authentic information with regard to when the 1985 Act came, who is going to benefit or how many are going to benefit under 6A2. There is no authentic figure even in respect of 6A3 because it is open-ended in terms of time. And we would respectfully submit that insofar as the notion of statelessness is concerned, it is just being raised without, because we ourselves say that as far as international humanitarian law is concerned and that proportionate response is concerned, that's the obligation of the state. We are not for a moment seeking to prejudice anyone in that behalf. Now, Manoj, I'm on my last point. And the last point is with regard to delay and leaches. Now, I'll just very, very briefly tell your lordships 3 or 4 issues. First, you will find the reference order itself has gone into this issue inter partes. That's one. And I said that we are entertaining this petition. So it's inter partes between the same parties that a determination has been made by this court. So we're not sitting in appeal over that judgment in the very same case. So that should bind. But the reference court left it open to your lordships to mold the relief appropriately. So that's my first point. My second respectful point is that if they accept, as they do, that this provision continues to operate and even tomorrow you can go and apply under 6A2 and 6A3, then in our respectful submission, there's no question of delay and leeches because it's continuing in every respect. My third respectful submission is that you have a situation now which is the aspect regarding culture, community, economic rights, which extends generation upon generation. So it serves and deserves to be struck down if we are correct. Even today, to protect what is left, despite this huge onslaught on our cultural and community rights. I'm very grateful. Thank you.
Thank you, Mr. Thank you, Mr. Diwan.
Wait, please, Your Lordships. My Lord, the first point I would like to deal with is regarding the delay, my Lord. On the point of delay, my Lord, as my learned friend Mr. Diwan has pointed out, my Lord, in para 31 of the referral judgment, my Lord, virtually, my Lord, this point has been rejected. And I'm sure this is not Lordship is not sitting in appeal over the reference court's order. Therefore, my Lord, as far as the issue of delay is concerned, that stands at rest. Yes, the reference court did frame one issue, my Lord, in view of the fact that these beneficiaries have enjoyed certain rights over a long period of time. Therefore, what view this Honorable Court should take at this stage? In other words, my Lord, it is in the relief mode of, my Lord, molding of relief, then to non-suit the petitioners, as the other side would like to contend. Therefore, my Lord, in my written argument, my Lord, I think at page 29, I have dealt with this issue, my Lord, in details, my Lord. I may indicate, my Lord, which are the pages.
That's all right. You've told us earlier. We'll find it out.
My Lord.
Just summarize
Just-
now what you want to
Yes,
say.
my Lord. Lord, kindly give me 15 minutes time, my Lord. My Lord, page 29 to 32 of my written argument of volume 1, my Lord. Now, my Lord, the government's affidavit, which they have filed, my Lord, government is trying to give an impression that what we are agitating is a trivial issue. It's a matter of 30,000 or not business. So what is great in it, my Lord? With all respect, I'll submit, my Lord. Is it the case of the government? They're construing this litigation to be an adversarial litigation, where, my Lord, millions of, my Lord, immigrants are in the state, where the local people have been outnumbered, and government would still like to go by legalism. With great respect, my Lord, this cannot be the correct position, my Lord. Now, my Lord, yes, it is a fact. It is very difficult to make approximation as to what is the exact extent of immigration which has taken place. That's very difficult, my Lord. The white paper published by the government of Assam also expressed the same difficulty. But, my Lord, there are contemporaneous facts from which one can come to the conclusion that this immigration is of substantial, and, my Lord, it has caused change of demographic profile and other adverse effects, my Lord. First, my Lord, I would like to place, for your Lordship's kind consideration, in the rejoinder submission, my Lord, I have volume 1A, my Lord. If your Lordships will kindly come to page number 3.
Why don't you do this like Mr. Diwan had formulated? In fact, I've taken
No,
down
I'm formulating.
14 submissions of Mr. Diwan. Now you just formulate point and then tell us what the,
my
because
lord.
we are now in rejoinder.
No, I know, my lord. What I'm trying to say,
So first is
my lord,
delay.
while opening also, my lord, I couldn't get much of time.
So delay, you have said that, you know, the reference judgment para 31, volume 1, pages 29 to 33.
I have dealt with that issue, my
All
lord.
right. Now what is the second submission?
My second submission is, my lord, I'm trying to, my lord, take a stand against the affidavit filed by the government.
So tell us the submission, formulate it now.
The submission formulate is, my lord, the extent of immigration is much more, my lord, than 32,000, the figure which has been reflected in the affidavit. So in this regard, my lord,
But that really doesn't affect the validity of section 6A.
what I'm saying,
Because assuming that the immigration is not 32,000 but 3,20,000 or 32 lakhs, the number of persons who are granted citizenship doesn't vary.
it has a bearing, my lord, according to us, subject to what your lordships may say.
Yes.
I'm coming to that. I'll come to the parliament's
Okay.
plenary
Extent
power
of
also, my
immigration.
lord. What are the limitations of that also?
All right, extent of immigration is more than 32,381.
No, much more, my lord. It is much, much more.
All right, what is the next?
No, my lord, I'd like to place two paragraphs. Kindly permit me at page 3 of my volume 1A, my lord.
Volume
1A
Volume 1A,
of the rejoinder submission.
para.
My lord, is second subpara 2,
Page.
page 3, my lord.
So what is the point you make there? Don't read
Point
it.
I'm trying to make is the Law Commission in its 175th, report on amendment of the Citizenship Bill, my lord, 2000 said that the immigration is of such an extent that it has the potential of, disturbing the unity and integrity of the country. It poses serious security threat to our democracy.
But
Then,
are you saying that the number of persons who are granted citizenship under section 6A
yes,
is more than 17,000?
millions, my lord. It will be more than millions.
How can that be?
My lord,
You
my
are
lord,
confusing.
as far as
Conflating persons who are illegal immigrants with those who have been granted the benefit of citizenship between 66 and 71.
no, my lord, regarding the first batch of from up to 1166,
Right.
then there's a second batch where only they would be, my lord, defranchised for 10 years after they follow the procedure.
Right.
That's the position.
Right.
And my lord, after 25/3/71, these people are to be deported in accordance with law. That is what the, my lord, accord is all about, and that is what section 6 is all about. Now, my lord, by conferring citizenship to this stream of people, my lord,
The first batch.
yes, my lord, security of our country has been endangered. That is what Law Commission says. That is what, my lord, the group of ministers also says. I'm trying to rely on those, reports of the government of India. So, my lord, Law Commission clearly says, Law Commission noted that entry of if a lordships will kindly.
You said says that there's a potential to disturb the integrity and security.
Yes.
All right, what's the
And
next?
that was an aspect which was taken note of it.
What's the next
And the
point?
next point is, my lord, after the Kargil war, the then Prime Minister of India constituted a committee or a group of ministers.
That's not a point. That's material. What is the point that you have?
The point which I'm trying to make is, my lord, the recommendation or the report of the committee reveals that there are, my lord, 12 million foreigners in northeastern India, and the report reads like this, my lord.
Where is the report?
At page 3 of volume 1A. Report is at the report is at, my lord, page 3 to
Mr. Chaudhary and Mr. Hansaria,
Hmm.
we are not going to extend hearing beyond 4 o'clock today.
Yes, yes.
Today we close.
My lord.
Whoever has not finished, whoever has finished, there's a guillotine at 4 o'clock today.
Yes, yes. No, my lord.
So no, this will not spill over to tomorrow because we have another CB tomorrow.
My-
So you've got about 34 minutes between the two of you.
Yes.
So you please ration time and
My lord,
between.
we'll
Yes.
share amongst us.
No, the last batsman can hit a first ball 6, you see.
No, my lord. No, my lord, run,
The others are
run
scared
required.
they'll get. The others are scared of getting out, so they don't try to hit a first ball 6. The last batsman knows that he can hit a 6 and there's nothing to lose.
The run required is 45 and only 2 overs is remaining. It's a difficult task. Anyway, my lord, the report is at place 3242 to 3351 of volume 4.
3242.
To 3351 of
Of?
volume 4.
All right.
It was headed by the then Home Minister of the country, my lord. And the relevant report, which I would like to read, my lord, is para 2.35 at page 3254.
Para
2.35,
at
page 3254.
all right.
And just a small paragraph.
Just tell us what
Yes.
it said. Don't read out. Just tell us, make the point. We'll
It
read
says,
later.
my lord, there are estimated to be about 12 million foreigners in Northeast. A host of problem has been created, including, my lord, economic, political, communal tensions, ethnic clashes. And one very significant observation regarding Assam was, my lord, 32% of the constituencies in Assam are dominated by these illegal immigrants. That means out of 126, 40 seats. Their vote is decisive in 40 seats.
One 126 constituencies, no?
Out of 126, my lord.
46.
32 makes it 40 point something. So it's 40. So therefore, my lord, in my humble submission, figures do matter.
All right. What's the next point?
Yes. Now, my lord, my friend Mr. Sival has mostly covered the points, my lord. Therefore, I will not repeat. I would like to emphasize on a particular point, my lord.
Yes.
What is the scope of Parliament's plenary power? Are we to understand it admits of no limitation?
Just formulate it so we
The
can.
formulation is, my lord, the power, plenary power of the Parliament, its scope and limitations.
We say, according to the plenary power of Parliament, is subject to limitation.
Yes, my lord.
Of course it is.
Yes. Now, my lord, from the facts which I have referred just now, my lord, what emanates according to us, my lord, subject to what your lordships may say, that making of this classification and creating this class of deemed citizens is posing security threat to this country.
That you've already said.
Yes. Therefore, my lord, as per the decision of the Honorable Supreme Court in Indira Nehru case, my lord, versus Rajnarayan, where Honorable Supreme Court says that amongst others, my lord, supremacy of the Constitution and unity and integrity of the country are also basic features of the Constitution.
All right.
Now, if granting of or conferring deemed citizenship to this class of persons, my lord, it poses security threat, is the object of the legislation not unlawful? Therefore, would the Parliament's power be not fettered by, my lord, the constitutional inhibition of violation of doctrine of, my lord, basic feature?
Yes.
Therefore,
Yes, Mr. Dev.
My lord, in RC Podwal's case, the
Formulation, what is the
Yes.
formulation?
now the formulation is, my lord, classification has resulted in creation of a class of citizen who pose security threat, which in turn would impair the nation's unity and integrity.
That point you've already made.
Yes. Now, my lord, here, my lord, I would like to refer on the judgment of the Supreme Court of this Honorable Court in RC Podwal's case, my lord. In RC Podwal's case, my lord, the question which arose was,
Bhutia lectures.
yes, what is the, the non-obstante clause,
Though they have 20% of the population, they had reservation of 38% of the seats.
and
in
one of
Assam.
the one person, one vote, that principle was also, my lord,
But
done
that
away
was,
with.
that was rejected by
Yes.
Chief Justice Venkatachala's judgment.
Yes, madam. No, what I'm trying to say is, I'm relying on paragraph 102, 175, and 176. 102 is by majority, my lord, and 176 is by judgment, by Honorable Justice Agarwal, my lord. Now, what I'm trying to, submit for Lordship's kind consideration is, the meaning of that non-obstante clause was, laid down, my lord. Now, issue was whether, in view of the non-obstante clause, while exercising power under clause F, they can undo the constitutional inhibition, my lord. There, this Honorable Court said, my lord, that no. Yes, the non-obstante clause would permit you to undo some of the constitutional provisions, but if it goes to the extent of overreaching or overriding the basic features theory, then it will be bad. Now, what I am trying to, the support which I seek to draw from the judgment is, my lord, by conferring citizenship right
Yes.
to this section of deemed citizens, my lord, the security and integrity of the country has been endangered. Therefore,
Made this point 3 times, Mr.
no, therefore the object of the legislation is, my lord, something which cannot be countenanced.
Thank you, Mr. Jodh.
Just one more point.
At 3:18, you said 15 minutes. It's now 3:34. So you've got 1 minute now. Almost 3:35 now.
All right, finally, my lord, I'll just urge one more point, my lord. Government of India very candidly says, my lord, that as far as the allegations we have brought out in the petition or the averments which were made in the petition regarding, my lord, the adverse effect of illegal immigration, they accept it. Now, is it not the government of India to do something, my lord? What have they done? While opening my argument, my lord, I made a submission based on Article 355 that it is the duty of the central government to protect the interest of the indigenous people of the state. Now, Lordship would recollect, while upholding Armed Forces Special Power Act, this Honorable Court had taken the view that Article 355 enables framing of a statute like, my lord, Armed Forces Special Power Act, where a non-commissioned officer, even a junior commissioned officer can, my lord, without warrant, even act in case of a non-cognizant.
According to you, government has not done anything that it accepts the impact of illegal immigration.
Yes, therefore they can't, my lord, accept the thing and at the same time not do anything. And on the contrary, coming up with these figures, my lord, to show as if it's a trivial issue. It's not a trivial issue, my lord. It's a very serious matter. Finally, my lord, I'll make one submission for Lordship's kind consideration.
But actually,
In the event,
they have not said that illegal immigration is a trivial issue. They are in fact saying it is a very serious issue. But they say that we can't give you an estimate. It is so large. I mean, and it's impossible to give you an estimate because they are all people who are clandestinely and surreptitiously in India.
If that is the position, absolutely correct, my lord. There's no difficulty.
That they're right also because they are not disputing the fact that it's a very serious problem.
Yes. And Lordship, as I have already submitted, Lordship will also consider the aspect.
Nor are we
Well-
for a moment even suggesting it's not a
Yes.
serious problem. Undoubtedly it
In
is.
that case, they ought to come up with a more stringent law as to how to deal with these foreigners instead of conferring them citizenship, my lord. It's an unheard of concept anywhere in the world. Where, my lord, own citizens are at the risk of losing their identity, they are protecting the, my lord, foreigners, don't
That
protect them.
point you have made.
Yes. Now, finally, my lord, having regard to the lapse of time, the numbers, we all appreciate, my lord, the practical difficulties. In the event your lordship is inclined to take the view that we will not strike down 6A, there my submission would be, my lord, let the post 19,748 stream of people be identified and let them be, my lord, relocated in these different states on pro rata basis. Why Assam alone should, absorb this disproportionate burden?
Even if section 6A is not struck down, the post 1971.
748, yes, stream of people should be identified by undertaking an exercise like NRC, and, my lord, relocate them to different states on pro rata basis across the country. If there is an humanitarian angle, if there is an Article 21 obligation, certainly these measures can be certainly adopted by the state, my lord. Why Assam is a very small state, my lord? The land mass is also very less compared to other big states.
We'll consider
So
that.
therefore, my lord, why not? They should also on pro rata basis,
We'll
they should
consider.
be, relocated in the other parts of the state.
Yes, Mr. Ansaria. Thank you.
Deeply.
Let me start with the disadvantage being the last investment, my lord. Lord, before I formulate, my lord, the Chief Justice asked a very pertinent question to Mr. Diwan. When he was arguing clause 2, deemed section, my lord, Lordship said the Constitution also provides Article 6, a deemed provision. Section 6A2, clause 2 says, my lord, deemed if it before 1/1/1966, no exercise is necessary. My lord, the Chief Justice said there is a Constitution also provided deemed fiction under Article 6, my lord. Would your lordship kindly see, my lord, Article 6 for a minute, my lord? It has limitations, my lord. If your lordship see, my lord, Article, just give me mine. The lordship give me, not mine. Yes, sorry. It is some. If your lordship see section Article 6, my lord, A, Article 6B2, which gives citizenship, my lord, to the persons who have migrated after 19 July 48. There are 4 criteria, my lord. Because, my lord, here also they are giving citizenship to the persons who have come after 19 July 48. They have to be registered as a citizen. They have to make an application. They have to make that application before the commencement of the Constitution, before 26 January 1950. And they have to be in India 6 months before. None of these conditions are there in clause 2, my lord, of 6A. It's open-ended, as Mr. Diwan has said, it's open-ended. Today also I say, my lord, I came before 1966. Constitution Article 6B2 does not permit that, Lord. You have to make the application before 26 January 1950. And you have to make an application. That application, Lord, so there's a fundamental distinction between clause 2 of section 6A and Article 6B2 of the Constitution, Lord.
6B2 came in because there was a permit system, as Dr. Ambedkar said.
Here also, that's what I'm saying, Lord. Here also, so far as 6B is concerned.
On 19 July 1948.
I'm coming to that.
Lord, it's a product of
Lord, that's what I'm saying. 6A3 says you have to apply. But so far as 2 is concerned, my lord, you are shifting the date, my lord. My first argument that you are shifting the date from 19 July 48 to, my lord, the 1st January 1966 by this legislation, my lord. You can do a 368 route. This argument will not be available to me, my lord. But by parliamentary legislation, you are shifting the date from 19 July 48 to 1st January 1966. And without those riders, which are there, you're making it open-ended. Even today, wherever there is, there was a time limit of 26 January 1950. Make an application so that people can authenticate, my lord, on that day. So that's a fundamental distinction, my lord, which my lord, the Chief Justice pointed out, my lord. And my lord, my submission is that 6A2 and my lord, Article 6 has a completely different scheme.
All right, then.
My lord, with this, my lord, may I just respectfully submit that draft constitution contained Article 5 and 6 only, which translated into Article 5, 9, and my lord, 11. It did not have Article 6, 7, 8, and 10, which were introduced during the debate by Sri Ambedkar, my lord, Dr. Ambedkar, on 10th August 1949, by way of 5A, 5AA, 5B, and 5C. And my lord, the debates which my learned solicitor read, my lord, in my respectful submission relate to the draft Articles 5 and 6. There's a different debate and Lord, expression of opinion by all the three learned eminent members of the Constituent Assembly on 5A, 5AA, 5B, and 5C. And my lord, our is, my lord, regarding 5A and 5AA, which is Article 6 and 7. If your lordship kindly see that, lord, it contains a complete code. I will invite your lordship's attention.
Mr.
Yes.
What is the
No, my submission is, my lord, that the submission of the central government, the learned solicitor, that the parliament was given due leverage to extend and amend under Article 11 does not apply to the persons who come under 6 and 7, that is the migration from Pakistan. And there is a clear distinction drawn by all the three eminent members of the Constituent Assembly in the debate. And I'll show to your lordship, it's from the debate only, my lord. What has been read to your lordship, my lord, relate to general powers of the parliament, no dispute. But not, my lord, those were covered by Article 6 and 6.7, which is Article 5A and 5B draft constitution. Would your lordship now kindly see, my lord, with this preface, volume 4, the debates, my lord, page 887.
You've made that point.
No, my lord, would your lordship, my lord, please permit me to read that.
We'll not read
It
now.
goes.
No, we are at the.
No, my lord.
Mr. Hansaria.
Yes, my lord.
You must understand, you are in a rejoinder.
My lord, I'm in the rejoinder, meeting the argument of the learned.
You made the point in your opening
My lord,
that look, these people, you have taken 25th March 1971.
my lord.
On 25th March 1971, they were citizens of undivided Pakistan.
They were the
The
Pakistan.
liberation takes place much later.
Yes.
Therefore, you can't confer on citizens of Pakistan any provision which is beneficial by virtue of the power under Article 11A, under Article 11, which is at variance with the date of 19 July 1948.
Look, what I'm saying is, I'm
Because
meeting the
19
argument.
July, according to Article 6, is comprehensive in its sweep and coverage of those who emanated from Pakistan.
I want to show that from the speeches made by the learned three eminent authors, my lord,
Have
because
you
my lord, the argument, the reason, my lord,
have you put it in your written submission?
my lord, I have, my lord, may I just,
They take it as
My
read.
lord-
We will read it later.
my lord, may I just say this, my lord,
Why
I'm not,
don't you go to the next point?
my lord, I will not
the
be doing justice to, my lord, my brief and.
All right,
people-
don't worry, we
people
are
of-
here to do justice.
My lord, may I just say,
You
would your
now
lordship,
to the
my lord,
next point
this is
now.
my lord main submission. Would your lordship just permit me to show 2 or 3 things, my lord, because the submission has been made by the learned solicitor that the due latitude were given by the, and from the speeches made by the Dr. Ambedkar, Alladi Swami, and my lord.
Constituent Assembly debate,
My lord, would your lordship-
we can't control the language of the provisions. So we got your point. You made that point right in the opening, that Article 11 cannot give leverage to Parliament to expand on the ambit of those who are granted citizenship by Article
And
6
that is
and
what,
7.
my lord, that the
And that's what they have
my lord,
done.
that is what the
It's a point
founding
which you have to
fathers said,
consider.
my lord, in the debate.
But we have to, it's a point worth considering. We'll consider it.
My lord,
Reflect on it.
I'm no doubt about that. My lord, what I'm trying to say, my lord, when extensively debates were read to your lordship, my lord, it was said the parliament has been given complete leverage, my lord. The three, my lord, eminent speakers, Dr. Ambedkar, Alladi Krishnaswamy and Kunjuru's statements were read to your lordships. I want to read, my lord, they were in the context of Article 5, 9 and 11, not in the context of, my lord, 6 and 7, which are draft article.
All right.
My lord, they specifically said, my
We have
lord,
noted it now.
We have noted, we will read.
my lord, may I just give the page number then?
Now just give us
Very-
the page number.
May I give the page numbers? Well, Dr. Ambedkar's speech starts from volume 4, page 887. Regarding this, my lord, Article 5A, and 5AA is, my lord, at page 892 and 893, in which, my lord, may I just only,
Now, just give us Dr. Then,
Dr.
Sir
Ambedkar.
Aladi.
My lord, Dr. Ambedkar said on 5A and 5AA at page 890
All right,
and
you made your
893.
point. Just give us
And
Sir
just one
Aladi.
sentence, my lord.
Just give us Sir Aladi's reference.
Aladi question from me, IR, my lord. The relevant, it starts at 953 on the same volume, which is on 12th August. 953 start, the relevant is 955.
All right.
And Pandit Kunjru's speech starts from 961. What is read to your lordship is 961. And the relevant on this 5A and 5AA is 962 and 964. And my lord, he clearly says this is extraordinary provision, nowhere available in the world. We are making it for an extraordinary situation like this has happened, and up to 1948 only. My lord, can the parliament extend the date, my lord, from 1948 to 66 or to 71? And all the three learned speakers, my lord, who are founding fathers, and they're the heart and soul of the entire constitution which they made, my lord.
All right, you've made your point. Now, what is the next point?
My lord, I think, my lord, if a lordship, my lord, I will cut short another point. Let me read 1 or 2 paragraphs from this, my lord.
All right, read your point. You're 12 minutes short of rising time.
I will try to do, my lord. That's the, I say the handicap of the last batsman, my lord. 962 to 964, yes, my lord.
Yes.
My lord, may I just read 955 for a minute, my lord? (955), volume 4, my lord. This is Aladi Krishna Swami IRS explaining 5A.
Yes.
5A is intended to provide for all cases of this mass migration, if I may use that expression, from Pakistan into India, and to provide for that class of persons who have made the present India as their home. I'll skip to that note. Certain safeguards are provided for clause 2, so as to make it quite clear that the authorities cannot accept migrated people as bona fide citizens of this country. That is the object of the clause. This is the provision to the effect that no registration shall be made. So, my lord, it requires a registration as shown to your lordship, Article 6(2)(b), B2, unless the person making the application resided in the territory of India for 6 months. So, there are 2 safeguards. There will be registration. There will be no registration unless the applicant has resided in the territory for 6 months. If 5A stood by itself, it would mean that even if person went to Pakistan with deliberate intention of making Pakistan their permanent home and remigrate to India, they might be entitled to 5A. In order to provide such a contingency, 5A is provided, then quoted, which is now, my lord, 6 proviso. There is no 7. There is no use of dealing with this subject if a person is deliberately and intensely chosen to be a citizen of another country. After question has arisen, after Pakistan has been declared territory independent from India, then there is no point in conceding the citizenship to such a person. But this proviso takes note of this important aspect, etc., etc. So, my lord, clearly deals with, my lord, what is to be, my lord. These are the extraordinary provisions, my lord, which has been said. And 962, my lord, Pandit Kunjru says, last 3 lines of 962 and 963. Now, 962, my lords, which we can kindly go. Last paragraph. Now I shall come to Article 5A. In this article has happened occupying the intention of the members since yesterday. It has been criticized on the ground that provisions undesirable, wide flow, open to the doors of citizens who have no moral right to be regarded. I do not personally agree. Because, let us consider calmly what 5A, that is Article 6, lays down, and the circumstances which require that such an article should form part of our constitution. Article 5A and 5AA, that is Article 6 and 7, contain extraordinary provisions arising out of the present extraordinary circumstances, arising out of extraordinary situation created by the partition of India. You will find no counterpart to them in the constitution of any other country. Then, my lord, they say that there are conditions which are prescribed. Now, my lord, Section 6A does away with all the conditions, my lord, with the founding fathers tried to justify for 6 and 7, Article 6 and 7. So far as pre-66 is concerned, no condition, no requirement. Which the founding fathers thought even 48 requires, my lord. And 50 requires. So, my lord, to say that, my lord, the founding father thought gave untrammeled power to the parliament to make law under 11 is not correct, my lord. These observations does not apply, or the statement does not apply to the extraordinary provision made under 6 and 7. That's my first submission, my lord. Second, my lord, Lordship would kindly see the Constitution, my lord, Article 7 starts with the non-obstant clause against 5 and 6. Article 7 says, notwithstanding 5 and 6. And 6 says, notwithstanding 5. So 7 takes precedence, my lord, and then 6, then 5. If your lordship kindly see that, my lord.
Yes.
So, my lord, if 7 is to be given precedence, that fixes the cutoff date as 1st March 1947. So anybody who has come to India, my lord, after going to Pakistan, after 1st March 1947, he does not get citizenship. Under 6, my lord, he gets a citizenship up to 48. And thereafter, my lord, he has to go by the registration and application, etc., etc. Now, my lord, the section 6A, 2 and 3, Mr. Diwan is there, so far as 2 is concerned, there are four requirements, my lord, and unending requirements. Even today, there is no cutoff required date, my lord, for that. 6A3 requires 2 more conditions, my lord. That is, he must be detected to be a foreigner by the Foreigners Tribunal, and he must apply for registration. Now, would your lordship kindly consider it, my lord, saying that as per the affidavit of the Government of India, 30,000 and odd has been detected to be foreigner till date. So it must, my lord, it cannot be open-ended. It must confine to those 30,000 and 30,000 alone. It cannot be, my lord, millions. But till after, in case your lordship is to held, my lord, 6A to be valid. My submission is, my lord, the 4 conditions which Mr. Siwan has said. And that is what I have said in my rejoinder submissions, my lord, which is circulated to your lordship, my lord. Those 4 conditions, plus he must be declared as a foreigner, my lord, by the Foreigners Tribunal, plus he must make an application, and this must be confined to the 30,000 people, my lord, because till today, my lord, 30,000 people has only been detected to be foreigner. Can it be said after 100 years, my lord, it become 3 million? Would your lordship kindly see, my lord, that written submission of mine, my lord, which you have circulated today, and in paragraph 9, my lord. Paragraph 9. Just 1 second, just a minute. Para 3. If they have not been detected till date, my lord, where is the question of granting them citizenship, my lord, up to the millions of people? As Mr. Chaudhary has said, my lord, it is an apprehension, it has happened. So lordship would confine in your judgment, my lord. That's what would your lordship kindly see, my lord, para 3 of my rejoinder submission circulated today, which is there before your lordship's screen, my lord. Six conditions. Right. Para 9, para 3 and para 9. Which says not the 6 conditions are mentioned in para 9. And my lord, I have submitted that thus the grant of citizenship to the person entering India after 1948 must comply with the mandatory this condition. It is submitted that the section 6A2 required expressly, and my lord, the Government of India said 30,000, so it must be confined to those 30,000 people and not beyond, my lord. That's our submission before lordship, my lord. Next submission before lordship is, my lord, when Attorney General, they have the plenary power, my lord. No doubt they have the plenary power, but it is not, my lord, if your lordship contradict this, my lord, see this Article 4.2 for a minute, my lord, and contrast it with Article 11. 4.2 says, my lord, no law made under 4.1 shall be deemed to a amendment to the Constitution. But Article 11 does not say so, my lord. So whatever law you made under Article 11 or 246 entry 1, entry 11, my lord, must be consistent with other provisions of the Constitution, which would include 6, 7, Article 14, etc., my lord. And there are 10 provisions, my lord, of the nature of Article 4.2. If your Lordship kindly see Article 4.2 for a minute, my Lord. It says, my Lord, no such law as aforesaid shall be deemed to be an amendment to this Constitution for the purpose of Article 368. For a minute, my Lord, kindly, Lordship, may kindly see. And my Lord, there are such 10 provisions, my Lord, which is in my written submission. Paragraph main written submissions, my Lord, volume 1, page 146, your Lordship would find. There are 10 provisions in the Constitution which says law made under this foregoing provision shall not be deemed to be an amendment to the Constitution. And that's not, my Lord. So if you cannot amend, my Lord, the Constitution by the circuitous method, in your Lordship's yesterday's judgment, 370, paragraph 390, my Lord, the Chief Justice has said, my Lord, you cannot use 367 method to change 370. This is the same thing, my Lord. You cannot use the circuitous method of a parliamentary legislation to amend the Constitution, which we can do only under 368 route, not the 346 route, my Lord. So that's my next submission before your Lordship, my Lord, for your Lordship's consideration. Just, huh? What should... And my Lord, I initially submitted, my Lord, that the persons who get citizenship under section 6 and 7, 5, 6, my Lord, they must take an oath of allegiance to the Constitution of India. So far as 6A is concerned, my Lord, there is no such requirement of oath of allegiance. And they come from, my Lord, a country in which it is recognized Islam is the Islamic country of Pakistan. My Lord, in my written submissions, I have said, my Lord, in case your Lordship is to help, that 6A is valid. Any person, Lord, even those 30,000 persons or 70,000 persons, they must subscribe an oath in the form of Schedule 2. And also, my Lord, they must say, if your Lordship kindly see my written submissions, my Lord, in this rejoinder written submissions, para 8, my Lord, Lordship may kindly make a note, my Lord. In para 8, I say that there is no answer to the oath of allegiance. And, my Lord, Rule 19.2 and Form 18, under which they make an application, my Lord. If your Lordship see that, my Lord.
Yes.
Have I, my Lord? I have another 2 minutes, my Lord.
Yes.
I have another 3 balls to play. Yes. Look, para 8 of my rejoinder submissions.
Yes.
I have noted, my Lord, under Rule 19.2 of the Citizenship Rule and Form 18 of the Citizenship Rule, they are required to make an application. In that application, Lordship would read it, my Lord. They must subscribe an oath in some second schedule to the Citizenship Act. They must additionally say, I believe in the secularism and I will uphold the unity and integrity of India. That's a very serious concern of us, my Lord. So those conditions, Lordship would incorporate that in case your Lordship were to help, my Lord, it is constitutionally valid. And finally, my Lord, the note by the Government of India says there are 100 tribunals, my Lord, and there are 96,000 cases. That means, my Lord, there are 1,000 cases per tribunal. We do not know how many years it will take, my Lord, to decide those cases. Just to your Lordship's, my Lord, note factually, 200 tribunals were constituted, my Lord, on 6/2/2020.
Sorry, how? 26?
6th of February 2020, 200 additional tribunals were constituted, my Lord, by the Government of India to decide these cases. But they were discontinued on, my Lord, 14th October 2022. I have that order of the Government of India, my Lord. 14th October 2022, all these 200 tribunals were discontinued, saying that there is no sufficient work. And in fact, I must point it out, some of the members of the tribunal filed a writ petition before Lordship, and my Lord, the Chief Justice said, my Lord, this is not a public interest litigation. Your term was under a contract, so you cannot go beyond that. And Lordship said that in case it is there, my Lord, then it will be considered in accordance with law. So what I'm saying, your Lordship, in case your Lordship will to held against me, there are only 100 tribunals. 200 tribunals were constituted. They were discontinued on 14th October 2022. They have to be, my Lord, all these cases to be decided fast, my Lord. It cannot be remain for another 5 years, 10 years, my Lord, these cases will pending.
Lord,
so those tribunals...
1 minute, my Lord. One important judgment is missed, my Lord.
Yes.
It's under 6A, therefore, my Lord, it's necessary for me to cite. Volume 5, page 5238, the relevant part. My Lord, 6, it starts at, my Lord, 5226. it was concerning. I would be missing, my lord, if I don't cite this. Since Mr. Diwan cited, my lord, this ordinary resident is not defined. In rejoinder, my lord, I did not cite it. It's on record, my lord. 6A2, my lord, your lordships have, my lord, page 65238, or I may read.
5238.
38.
Just, give us a citation.
Yes, my lord, it's 1994, supplementary 1 SCC, page 615. Paragraph is 62. So please read, it's a short, my lord, 5-line paragraph under 6A subsection 2. I'm sorry, condition number 2 of 6A. But 5238, my lords. My lord, may I read para 62? Turning to condition number 2, the requirement is ordinarily resident in Assam from the date of entry till the incorporation of section 6A, namely December 7, 1985. As to the meaning of ordinary resident, we may refer to Shanno Devi versus so-and-so. This is a constitution bench. We find the following observations at page 590 apposite. It is not necessary that for every day of this period, he should have resided in India. In absence of the definition of the words ordinarily resident in the constitution, it is reasonable to take the words to mean resident during this period without any serious blame. That's it.
Anything else? Thank you.
I'm extremely grateful, my lord.
We have
Lord, in
heard
the
so
rejoinder submissions, my lord, because I had very limited time. In the rejoinder submissions, my lord, whatever I have said, my lord,
Certainly.
file today are there, my lord, before your lords.
Certainly.
Lord, lords, I would
Thank you,
consider.
everyone. Thank
Grateful
you.
to you all.
We're extremely grateful to your lords.
Yes. That has to be
It was to
detagged.
be detagged, my lord, that's so, yes.
That detag that. एक बार check कर लो, please. Not on 6A. Detag कर लो. Yes.
Grateful to.
Please, your lords.
A lot of people say, oh, 8 times Olympia, but now he's dealing with injuries. What's your response to those people? When was the first time you took steroids?
I was 30 years old. I was so afraid to do all that stuff back then.
When you have that kind of a body on you, how does someone's sex life change?
Oh, too much sex. Bodybuilding is probably the hardest sport in the world.
Yeah.
It's a lot to go through, and it's not rewarding at all. I mean, the food I had to eat to win that first Olympia, ain't no ordinary person could have done that.
Are you able to look at someone and say that, okay, this person's probably done steroids?
Oh, yeah.
I'm going to show you some very famous international physique.
Look at his legs, there's nothing there.
This is not naturally achievable because he's not an athlete.
Exactly. He's pretty much an actor, you know.
Not going to make this intro very long. All I'll say is that this legendary podcast with this legendary guest is meant for international audiences as well. I did ask him a lot of India-specific questions, but I promise you, I've tried my best to reveal another side of Ronnie Coleman. He's one of the purest people I've had on the show. And if there was one guest I'd pick from the world of bodybuilding to come on my podcast and talk about life in general, it would be Ronnie Coleman. So we've touched upon fitness, we've touched upon life, we've touched upon mental health, we've touched upon some of his bodybuilding hacks. I hope you enjoyed today's episode because it was one that I enjoyed recording very, very much. It's Ronnie Coleman on TRS. Ronnie Coleman, welcome to the Ranveer Show. Welcome to India.
Oh, it's good to be here. I look forward to coming every time I come.
How many times have you been here?
I've been here at least 5, 6 times, somewhere in there. And every time I've come, I've always had a wonderful time, had a great time. great hospitality. They take pretty good care of me every time I come. So that's why, I love coming here.
Do you have any idea how much you're loved in this country?
Oh, yeah. I found that out probably the last time I was here. We had an appearance in the mall, and the mall was so packed and so full, they had to shut it down.
Yeah.
Yeah, and the appearance didn't go so good because it was too many people.
Yeah. Usually before every episode, I do a lot of research. So I call people related to the field.
Oh, okay.
Like
yeah.
in terms of if I'm talking to you, I'll call people related to
Yeah.
fitness.
Yeah.
I didn't want to call anyone because I knew everyone would say, make me meet him. Like everyone's crazy about you in this country. Anyone who's ever lifted weights in this country loves you.
Yeah. I've grown to know that fact by now.
How does it feel?
Oh, I'm so even keeled and so humble that it's just great. It's not up there where I winning my first Olympia, because there was an overwhelming, exciting feeling, but I just try not to let it get to my head for the most part. Just enjoy the love and soak it all up.
Nice. What was it like winning your first Olympia?
Oh, it was the most amazing thing that will ever happen to me.
Did your heart cry?
Oh, yeah. I blacked out for about, I want to say 10, 15 minutes almost. I think I went back and looked at the tape, and so much happened when I fell on that floor. Consciously, I was awake, but unconsciously, I really wasn't. So, it was just one of those overwhelming feelings of excitement that kind of like put you unconsciously conscious.
No, I hear you. But when you regained consciousness,
Yeah.
what was the first thought in your head?
Oh, the first thought in my head was, this is not happening to me, because I never got into the sport to win the Olympia. I got into it just for a free membership to the gym.
Yeah.
And here, lo and behold, I won the highest title, because when I was coming up, they really didn't look at me much. I got overlooked a whole lot.
Why do you think that is?
Because a lot of times the guys, when they turn pro, they have a lot of fanfare. They turn pro in the U.S. and the organization, the NPC, pretty much widely I know them already. With me, I didn't have that fanfare. I turned pro like in a year. Most guys, it take about 5 years, and they build their popularity up. I didn't get a chance to do that, and plus, I didn't turn pro in the U.S. I turned pro in Poland, another country. So I had no fanfare. They didn't know who I was or where I came from or nothing. And when it's like that, it's like you're not known to the industry. So they don't really call you out. They calling out the guys that are well known and that has built that fanfare up.
Yeah. Loneliest phase of your life?
Oh, I don't really say I've had a pretty lonely phase, because me and the family, they've been with me everywhere I've gone. I remember when I graduated college, they came. I was from Louisiana, and I lived in Louisiana my whole life. But when I graduated college and I moved to Texas, once I got established, my whole family came there, and we're still there. So I hadn't had too much loneliness in my life, because I've always had my family real close by me, and we've always been real close knit. So it's been a wonderful experience my whole entire life.
One of the, while people have a lot of thoughts about the world of bodybuilding, there's positive thoughts and some negative thoughts. One of the negative thoughts is, bodybuilding is a lonely sport. But if someone meets you, you wouldn't feel so. Because one of the other negative stereotypes is that bodybuilders are sad people, but you're such a happy guy.
Oh, no. I'm totally opposite. Like I said, my whole family has been behind me. My first contest, my whole family came to it. My mom, my brother, sister, everybody. And it was like that, for a long time. I would even compete in other countries, and they would come to other countries to watch me compete. And of course, when I won the Olympia, they were always there. And when I competed in the Olympia, they were always there. And when I won, they were, there. So my whole family, we've been pretty close this whole entire trip, this whole career that I've had. My whole family has been there. Even when I was winning all the Olympias, my family was there helping me with fan mail. It was helping me with my food. My mom cooked all my food.
Oh, wow.
Yeah, my
Throughout your career?
Oh, yeah.
Damn.
Yeah.
So those 6 meals you had a day were actually cooked by mama?
Yeah, exactly. And, my brother, he would help me with stuff, car stuff or whatever I needed help with. My sister would help, clean the house and wash my clothes and everything. So
damn,
everybody pretty much in the family had a job, and they all helped out, the whole career.
So that's how you win 8 times?
Yeah, eight in a row, 98 to 05.
Wow.
Every last one of those were hard. It was like after I won one, I get maybe a day or two to enjoy it, and then it's right back trying to get ready for the next one. So I'm just now, kind of like getting the thrill of the enjoyment of winning, because I don't have to get ready no more. I can sit back, relax, and soak it all in, and do stuff like this, and explain to people how hard it was to actually win those, because there was some real dark times, real dark days. Now, if you want to talk about loneliness, try being, maybe I was kind of lonely when I was getting ready, because I couldn't go anywhere. I couldn't go out to eat. I couldn't go to dinner, which is out to eat. I couldn't go to movies. I couldn't go to parties. Couldn't go to weddings. I couldn't go anywhere. And I couldn't do anything either. I couldn't go like the amusement parks, couldn't go just hang out, couldn't just hang out with friends and stuff.
Everything was about bodybuilding.
Yeah, everything was for bodybuilding,
Okay.
So, yeah, those are some pretty dark days.
This is basically throughout those 8 years, and
Yeah,
even before
exactly.
and even after a little bit.
Oh yeah.
So-
Now, after it was over with, no, it was it was time to relax. But, I'm saying after my career though, not after I won one, because like I said, after I won one, it was time to get ready for the next one, because this is a 365 day job pretty much for the most part, because you can't really slip up,
Yeah.
because you got guys out there trying to take your title. They want it just as bad as you do, because they are working just as hard as you are. So you gotta stay committed.
So what's the edge? Why did you win so many times?
Because I stayed committed, and I trained even harder. After I won, I can remember sometimes, when they were trying to take it away from me and trying to change up the sport, and I would go and like really train extremely hard. I'd go to the gym with an attitude, saying, stuff like, if they want to go to war, I'll take them to war, and they ain't gonna take this away from me. I do stuff that, I know other bodybuilders won't do,
Yeah, so
like squat 800 pounds, deadlift 800 pounds, leg press 2,300 pounds, bench press 500 for reps, all that kind of stuff.
So, I mean, it's a bit of a direct question, but do you think that because your volume of training was more than the other guys, that's what your technical edge was? But then there's also this attitude edge that you're talking about. The
Oh yeah,
commitment.
I know for a fact that was my tactical edge was. 'Cause, like I said, I was doing stuff that other bodybuilders wouldn't do.
Which is heavy
And
lifting.
probably couldn't do either, because I was so determined, so focused, so motivated, so dedicated, and I'd always persevere through just about anything, any kind of obstacle that's kind of like stood in my way. And my faith was always real strong too. So I had just about everything at my disposal that I really needed to, go out there and win 8 Mr. Olympias in a row.
I'm also sure that there was an element of visualization, this whole mind-muscle connection. But
Oh,
I just
yeah.
feel some guys have it more to have a cleaner mind-muscle connection.
Oh,
And
yeah.
as I hear you talk, as I was researching for this podcast, I realized how much mentality is a part of who Ronnie Coleman is.
Oh, yeah.
Fair to say that that was another edge?
Oh, yeah, for sure.
That when you were lifting weights, you were just with the weights and with your own body.
Oh, yeah, for sure. Most of the time, I had already done it before I did it, because it's a visual thing to actually go in there and do it before it's already done. I can still remember that when I was going to squat 800, about 2 weeks leading up to it, I pictured it in my mind how I was going to do it, how I was going to go. And, I'd never, ever done that before in my life. And so I just because I had already done it, deadlifting. And I know that anything I can pretty much deadlift, I can pretty much squat, because I've been powerlifting for a long time, and powerlifting is deadlift, squat, and bench. And my deadlift and my squat was always pretty much the same. If I could deadlift 500, I could squat 500. If I can deadlift 700, I can squat 700. So when it came time for me to actually get up under that bar, I had already done it probably a million times in my mind, in my head, and nothing wasn't going to stop it. And that's probably why I did too, because, in my mind, I was going to do two, even though I had, like at least 6 or 7 that I could have went on and done. But that's one of my biggest regrets, that, I had already pictured myself doing 2, and that was it. If I'd have maybe pictured myself doing more than that, I probably would have done it, because it was like, I know my strength, and the first rep was real light, and it was like 800 felt like 100, to me. It wasn't like 800 feels like 800, but when I deadlifted it, 800, it felt like 800. It was heavy, but I had the strength to pull it up, because I've been doing it for so long. People don't understand how long it took me to get to that 800, I think I started powerlifting when I was 14, 15 years old, doing deadlifts and stuff. And I didn't do that 800 till I was almost 38 years old. And it took me that long to get to that, because I couldn't have done it before then, because I had been trying to deadlift. I remember when I first tried 750, and it was like 5 years before I got to 800. And oh man, I wanted 750 so bad. I tried everything in me to pull that up off the floor, and it just wouldn't come past my knees. I got it up to here. You know, I couldn't lock it out like you're supposed to do before it to be official. And I remember that day like it was yesterday, you know.
So correct me if I'm wrong. I personally feel because you lifted heavy and you had that base of powerlifting, you were able to pump out a lot more volume, which helped your bodybuilding journey. But also you had an athletic background. Like you were training to become a footballer. I'm sure that helped you a little bit.
Oh yeah, for sure.
At least, you know, for the powerlifting, which then helped you for the bodybuilding.
Exactly, for sure.
Would you say that modern day bodybuilders need to lift heavier? Because currently the narrative, it's different for different people because everyone's bodies are different.
Exactly.
But the narrative is about lighter weights and more reps.
Exactly.
But do you think that the way you went was the more effective way to gain size?
Exactly, for sure. Size, definition, and thickness. Because when the muscle is very thick, it looks bigger than what it is, you know, than a muscle just sitting there, you know. When you add thickness to it, it is that much bigger because
that sexy density.
Yeah, it is that much bigger because there's so much thickness into it now.
Yeah, that's what stood out about you. That's how we all remember Ronnie Coleman.
Exactly.
You know, even with the modern day bodybuilders, you'll always have these gym conversations where someone brings up your name and says, like, no one's like Ronnie Coleman.
Yeah, because nobody lifted like I did to get that, you know, thick muscle that I had. But I remember how good it was back then. And now I'm like, you know, can't believe I had that, you know.
How did it feel when you were at your biggest? I'm assuming at your 8th Olympia, you were at your biggest.
Yeah, like I was saying, you know, I didn't even think about it, you know. I didn't even consider it. And now that it's all over with, I go back and I look at all those pictures, I'm like, wow. I did that.
But you didn't feel like a war machine or anything?
No, I'm gonna be honest with you. I did feel invincible because I remember, you know, when I was deadlifting 800 and squatting 800, I'm like, oh man, ain't nothing I can't do. That's when I got to that 2,300 pound leg press, it was like, this ain't nothing for me, you know. Ain't nothing I can't do. That's why I got it for like 9 reps, you know, instead of like 1 or 2 or 3. I ain't gonna have no regrets on this one.
Before you went up on stage for a competition, say for an Olympia, what was the energy with the other guys like?
I really didn't pay too much attention to other guys when I was out there. I had a connection pretty much within myself and maybe with the audience because I'm up there trying to entertain and trying to enjoy myself at the same time, you know. So, you know, you're trying to put on a good show and you're trying to have fun at the same time. So your mind is focused on that. And you're so focused on it that you don't think about nothing else but that. So the whole time, you know, I'm up on stage, I'm thinking to myself, you know, I got a routine I got to remember, first of all. And then I'm like, okay, got to have fun with this. And, you know, I got to entertain the crowd too while I'm at it. So you're thinking about so many things other than, you know, the competitors.
Okay. How does daily life change when you have that kind of a body on you? Like, for example, sitting in a car. Or, you know, trying on clothes. Or if you don't mind me asking, like, how does someone's sex life change with that kind of body?
Oh, too much sex. That's for sure. But as far as, you know, like sitting in a car, there was some cars that I had bought and I had to get rid of because I gained too much weight for them. As far as trying on clothes, the only clothes I could try on were the ones that were tailor-made for me. You know, I can't go to the store and just like try on a suit, you know, and all that kind of stuff. No, and go, you know, pick out a shirt. That ain't gonna happen.
Tailored clothes for Big Ron.
Yeah. Even the police department, you know, From day one, my uniforms were tailored, the first day on the job, because even when I started working for the police department, I had probably 22-inch arms already. I was already pretty big. And, I've been training for about started when I was about 12.
Wow.
So, these 15 years or so, and when I say 15, I'm talking about 15 straight hard years, because like I say, I was on the powerlifting team most of that time. And I was very athletic, playing football and stuff most of that time. So I was always working out,
What was your position in football?
Middle linebacker.
Okay, gotcha. That's like defensive, if I'm...
That's kind of like the quarterback of the defense. You call out all the plays and everything.
Like the captain of the defense.
Yeah, captain. You give out all the signals and everything.
Got it. Okay, coming back to your clothes.
Yeah. Everything, everything was tailor made. From like I said, even my first day on the job at the police department, they had me go to the city tailor. I had my uniform fitted.
Damn.
Vests, everything,
I wouldn't want to be a criminal in your city with Ronnie Coleman as a cop. Super cop coming at you.
Yeah, because I was pretty hard to deal with.
Did you see some twisted shit when you were a cop?
Oh, yeah. You see crazy stuff, there's a lot of murders and, happening out there, and a lot of bad stuff, a lot of suicides and all this, gangs, fighting, domestic violence. You see it all.
Did you ever see anything that messed with your mind a lot?
No. Some of the stuff, I saw, I can still remember, but, nothing that just,
Was there character building in that phase?
Yeah, I've always been real strong-minded. I can look at things and see certain things and just kind of like rationalize it, within my mind. Because like I said, I've always had a real strong faith, and I've always believed things happen for a reason. Certain things are going to happen. Also, you can't prevent a lot of violence, and it's here to stay. Forever. It ain't never ever going anywhere.
Maybe that's where your humility comes from.
Yep, exactly. I can guarantee that's where it comes from.
Yeah, you're honestly one of the biggest legends I've had on the show, but you're also one of the most humble people I've had on the show. Let me just tell you that.
Yeah.
And we've done like almost 600 people on the show.
Yeah.
Something very different about you. You're like, I'm saying this with a lot of respect, sir, but you're like a child on the inside.
Yeah.
You're like, there's a kid alive inside you.
Because I never let anything really get to me, because I've always been even killed about just about everything, Because like I say, my faith has taught me that bad things are going to happen to good people. Bad things are going to happen to bad people. It's just evident. It's just cycle of living, pretty much, And ain't nothing I can do to stop it. It's just part of life for the most part.
Did you ever have a phase where you were becoming arrogant with that kind of body?
No, because like I said, I've always been humble. I've always been even kid. I've always knew certain things were going to happen, and wasn't nothing I could do to change it, Yeah. I've never had a closed mind. My mind has always been open to everything. I remember when I walked up on, a double murder that I worked, I'm like, oh, okay, here we go again. Another one gone, another two people gone, actually. But, it's just the circle of life, like I was saying. It's just going to happen. bad stuff is going to happen to good people. Matter of fact, these were two good people that had let a homeless guy move in with them, you know, and he decided he was going to rob him and take the money from him, and they weren't going to give it to him, so he shot him and killed him.
Damn.
And they were good people, you know, just trying to help a guy out. He shot him and just walked away like nothing happened. Picked him up walking down the street, you know, like, oh, it's a crazy world we live in. Stuff like that happened, and there ain't nothing nobody could have did to prevent it.
Man, you've seen life. Like, you know, I'll tell you what, I've grown to respect the sport of bodybuilding so much because I have seen what it takes with some of my friends who are into it, and they're not even competing they're competing on a very normal level, like just for fun.
Yeah.
And I can't imagine what your mind has been through.
Exactly. I've tried to rationalize this within my own mind, you know, by saying bodybuilding is probably the hardest sport in the world.
Yeah, 100%.
You know, even football players, basketball players, they go through a lot. Even golf, you know, you go through a lot to get to, you know, where you are. But bodybuilding is totally on a completely different level, you know. Totally on a completely different level.
Is the boringness of it the challenge?
No, yeah, it's the boringness, and then, you know, the recycle thing of having to do the same thing day in and day out, and, you know, you can't go anywhere, you can't do anything, you know, if you want to be good at it, you know. If you want to be 8-time world champ, it's a lot to go through, and it's not rewarding at all, you know.
After winning 8 Olympias, that's what you feel?
It's not rewarding. I mean, I got $100,000 for winning each one. You know, look at these guys, and look what I had to go through to get it. You know, all the shots I had to take, and all the food I had to eat, you know, stuff. You have to stuff yourself. If you want to be big, the only way to get big is eat food. That's the only way. And I didn't know that, you know, coming into it. I thought if I lifted a lot of weight and lifted real heavy, you know, I would get out more muscle. I didn't know you had to eat so much food until I, you know, won my first Olympia. I'm like, God, I mean, the food I had to eat to win that first Olympia, ain't no ordinary person could have done that.
6 meals a day.
6 meals a day.
A pound of chicken in every meal.
Yeah, and I can't do it in a day. I have to get up in the middle of the night and go and eat and go back to bed. You know, you have to eat regardless of whether you're hungry or not, you know.
So there were days where you'd stuff yourself just to get the protein in?
Yeah, exactly. Mm-hmm. And there were days I had to stuff myself for a long time before my body got used to eating that much food. Because when I got with my nutritionist that helped me to win those 8 Miss Olympias, I didn't eat that much, and because I didn't think I had to. I thought, you know, if I just go and work out real hard, take some of the drugs that we have to take, you know, I get the muscle. Oh no, no, you're not. You have to eat, and you have to stuff yourself.
That's the biggest challenge?
That's the biggest challenge, is, you know, stuffing that all that food. You know, I used to eat, 10 ounces of food and thought that was enough, you know. My nutritionist was like, you got to eat 16. I'm like, whoa, that's a lot of food. And I'll sit there and I got to 14, you know. And I'm like, I didn't try to eat just 16 at one time, because I'm like, I looked at it and I'm like, oh no, I can't eat that. So I'm gonna start with 13 or 14 and work my way up.
Do you poop a lot?
Oh yeah, after every meal, just about.
After every meal?
After every meal.
So you're pooping 6 times a day?
Exactly.
Damn. Did you ever have days where you didn't have motivation to do all this?
No.
You were motivated throughout?
Oh yeah.
Why?
Because I wanted to be the world champ. And I'd be willing to do just about anything to be the world champ.
Why did you want to be the world champ?
Because you're the best. The best always get the most respect, you know. And you want to be respected for all that hard work that you put in.
Respect.
You want to be respected for all that hard work that you put in, you know, because there are some other guys out there working, you know, hard too that don't get it, you know. Like me, before I won, you know, I was working just as hard as I was when I won. A little bit different, you know, a little bit different from not being Miss Olympia to me being Miss Olympia.
Okay.
For me to win the Olympia, I had you know, increase everything. I had increased my cardio, my food, my supplements, everything. You know, I had literally changed to another person.
You know, so I'll be very transparent with you about something.
Oh, okay, yeah.
I don't know if this is the case in America, but in India, in a lot of gyms, you'll see two kind of fitness enthusiasts. The first one is just in fitness for fitness. The second one, and this happens in a lot of Indian gyms, the second one is slightly insecure and they compare themselves to other people and they'll try pulling down other people. They'll insult other people for losing some size. I don't know if this is the case in America.
Oh yeah, for
sure. It is the case. There's always two kinds of people.
Yeah.
There's the positive energy guys and the negative energy guys.
Hell yeah, so for sure. Same thing.
Same thing happens there?
Yeah, same thing.
So the negative energy guys are always competing with each other. There's a lot of angst around them, which is why a lot of kids actually leave the gym. They don't want to be in that environment with those kind of guys.
Yeah,
and all the negative energy guys are kind of filling their sense of confidence through their bodies because they're actually insecure about something else that they're making up for in the gym.
Exactly.
I don't sense that at all from you. You're like a peak positive energy guy. But so, you know, the negative energy guys have something to say about the winners, especially because a lot of people enjoy watching winners fall. You've sensed this?
Oh yeah.
So,
a lot of people, you know, I've been, I've had the worst critics out there.
Yeah. So with you, a lot of people, you know, they say, oh, 8 times Olympia, but now he's dealing with injuries.
Yeah.
That's one of the, what's your response to those people?
I'm still an 8-time Miss Olympia.
How do you feel
regardless
when someone says something like that?
It don't affect me at all because nobody knows how I feel about it. Most of the time I don't even read that or hear about it, you know. Somebody had to tell me about it.
I'm sorry, I didn't mean to.
No. Come on now, you know, I'm aware of it. That's why I don't read about it. Sometimes I do, you know, sometimes I don't. But and nothing can really bring me down, you know. I've been a positive person my whole entire life, you know. You think I'm gonna let somebody say bring me down? Come on, I'm probably one of the luckiest guys in the whole wide world. You know, God gave me the gift that he didn't give nobody else on this earth. So why should I ever be sad or mad about something? Yep. You know, so I got a reason to be extremely happy for the rest of my life.
Yeah. And it's very genuine happiness. Anyone who's listening to this podcast can feel your happiness.
Yeah, exactly. Because ain't nothing nobody can do to bring me down. Nothing. Yep. Nothing. You can say what you want to say.
You spoke about God's gifts for you.
Yeah.
Do you think that genetics plays a very big role in bodybuilding?
I know for a fact it does.
100%, right?
If God don't give it to you, you ain't going to get it. It ain't going to happen.
Was your genetic gift both the size and the strength?
Exactly.
That was your genetic gift?
Yep, exactly.
But what would you say would be like Phil Heath's genetic gift or Jay Cutler's genetic gift? Same things?
No.
Different things?
Different things, yeah.
Like what would be theirs?
Probably size and, you know, I mean, if you want to say strength, it's going to also be on another level. It's not going to be on a normal person's level. They're on the same level as another bodybuilder.
Gotcha. No, fair.
Not like mine.
I have to ask you this one question, and please give us a very transparent, brutal answer, because you're the only person who can answer this.
Exactly.
Why do we not see a Mr. Olympia competitor from India? Do you think it's genetics? Do you think that's the reason? Do you think it's training? Do you think it's the diet?
Oh yeah, for sure.
Which factors?
All of them you just mentioned.
All of it.
Yeah.
I have a strong belief that Indians are genetically really blessed here.
Yeah.
Like we're great at technology and mathematics. But
because it was the Indian doctor who fixed me. I had gone to these American doctors for, I had my first surgery in 2015, and he finally fixed it in 2018, 19. They kept putting all these screws in me that kept breaking. I went to him, he put screws in me that's still there.
As in the Indian doctor was good.
Yeah, exactly.
So I know for a fact that Indians are high IQ and really good at like brain related stuff, but we're not necessarily the most athletic. There's some parts of the country which are really athletic up in North India, Haryanvis, Punjabis.
Exactly.
I mean, I'm generalizing here, but North India has a lot of athleticism, especially.
Exactly.
But I don't know if you've interacted with too many North Indians. You probably have. But do you think those genetics are good enough for the Olympia stage?
Oh, yeah, for sure, yeah.
They are?
They are good enough, yeah. They're good enough, but you also got to have the mentality. You got to have, you got to do what it takes to get on that stage, Some guys may not want to eat certain things, like beef and, all the stuff bodybuilders have to eat to be the best, I ate a ton of beef.
You think
ate a ton of chicken, ate a ton of turkey.
Red meat plays a big role?
For me it did, not a big role because I only ate it once a day. Mostly it was just a lot of chicken, for the most part.
Do you think just with chicken and fish you'll be able to build a
yeah, for sure. Yeah, for sure. Okay. You can. But you probably can't look like I did.
So you think red meat actually is one of the reasons you had that kind of thickness?
Oh yeah, for sure. Yeah. I know for a fact it did.
Can I give you a very layman's perspective? Like I'm not a bodybuilder, but I've lifted weights for a while in my life. I'm vegetarian for the last 5 years because of my yoga. I'm more into my yoga is my focus right now. But I ate meat for 25 years of my life. A lot of vegans will say that, no, you'll be able to build a body with vegan. I don't believe that because I've been on both sides. I've tried veganism as well. You do lose a significant amount of size and strength when you leave meat.
Exactly.
You agree with me, right?
It's normal. Because protein is what builds muscle. You got to eat a lot of protein.
Yeah.
And that's why, I eat 600 grams a day.
How much protein do you eat now?
Maybe about 200-300 grams a day.
Okay, even that's a lot.
Yeah, exactly.
Why do you need to eat that much now?
Because I'm still a big guy, so I still have to eat, kind of big,
Okay, fair.
Because before I got in bodybuilding, I ate a lot of, meat, I ate a lot. I ate a lot, even before I bodybuilt.
Do you eat like junk food occasionally now?
Every now and then, yeah.
What do you like eating?
I might have a bag of chips or soda, here and there.
Okay. Do you like Indian food?
No.
Too much masala?
Too much spice.
Too much spice.
I can't do with spices. I'm used to eating bland food,
So that's what your system
pretty
needs.
Much my whole entire life, I've eaten bland.
So when you eat a little Indian food, does it become too much for you?
It's way too much.
Like your system heats up.
Like my system, it comes right out of my system. Like 2 bites, and I'm in the bathroom.
Because your body's used to
bland
non-spice
food, non-spice. And you try to put some spice in there, like, no, don't do that to me.
Damn.
Get this out.
So when you're traveling in India, what do you eat?
Plain chicken, maybe with barbecue sauce on it or ketchup on it.
Gotcha.
Yeah, and I try to find like, buffalo, they don't have a lot of beef here, so I'll eat buffalo, cause it's the same to me.
Right.
Buffalo and beef is pretty much the same to me. And all the other stuff that I eat,
Fair.
I don't eat a lot, it's just mostly chicken and steak,
Are you comfortable talking about the steroid side of things?
Oh yeah.
So-
Because everything that I put in my body, I was doctor prescribed, So,
Yeah.
And every 4 months I would get a checkup, make sure liver was right, kidney was right, heart was right. I have everything checked.
Was there ever a phase
I
where
never had a problem.
there was never a phase where something was wrong, like the heart, kidney, because a doctor was guiding you through the whole
Exactly.
process?
Do the whole process.
is
And
what-
I was getting everything checked out.
This is what most people don't understand about using steroids.
Yeah,
That you
yeah.
need a doctor to write you a whole plan.
Yep.
A regular
And
gym trainer may or may not be able to
and
help
you
you.
need to have your body checked out at least 6 months. Don't go 6 months without checking it. I've never went 6 months without checking it. Even now.
When was the first time you took steroids?
It was probably 1995 or 1996, somewhere in there.
You were 29, 30.
I was 30 years old, the first time ever.
Okay.
Mhm.
And
I can remember, like it was yesterday, because I was so afraid to do all that stuff back then.
who told you
well,
to do it?
Well, I got a lot of information from Flex Wheeler. He gave me a lot of information. Flex had, he'd been around, he won a lot of stuff. And I'm like, man, I wonder what he's doing. So you want to find out from somebody what they're doing, you go straight to them and ask them. You don't go to, some fan on the street, or you don't go to his friend. You go to him, Yeah, and hopefully he'll tell you, And with Flex, he was quite honest with me, because everything he told me, worked.
Do you remember the dosage and what you took?
No.
Okay, don't worry.
It's been so long ago. It was just normal. I just know it was like normal dosage. People think I took, like massive amounts. I'm like, no. If I'd have took massive amounts, I don't think I'd be sitting here, Like I said, the amounts that I took, I always checked and made sure that my body was functioning right and everything was functioning right. That's why I looked like I did on stage. Even though I was big and muscular, I looked healthy. If you go back and look at you look at my skin, some guys, their skin is bad when they up there like that. I didn't have a lot of, my skin wasn't bad at all, I see it for myself. I'm looking at the other guy with all these pimples and all this red marks all over their body, and I'm like, holy hell no, I wouldn't want to look like that, and all these veins everywhere and crazy, like, oh man. I'm not trying to go out like that.
You prioritized your health, which is why you did it with a doctor.
Yeah.
And because your health was great, your training turned out great.
Yeah, and my body turned out great too on stage.
Yeah, my question
everything.
to you is, were there guys who probably did a bigger dosage than you did?
Oh, I know for a fact, though. I talked to a few of them that did. Like, no, dude, I'm like, they ain't doing nothing like that.
Is this also a culture in the US? Because it's a culture in India where a lot of gym trainers actually give 18-year-olds steroids. They give teenagers steroids.
Yeah.
I don't know if that's a culture there.
Oh, yeah.
That is a
of
culture.
Course. Yeah, it is. Yeah.
Do you have anything to say about that? Like,
Hey, me, I don't judge anybody. I always say to each his own. People going to do what they want to do. You only got one life to live. It is up to you to live it how you want to. For me, I don't want nobody telling me what to do. Like you say, I didn't take steroids until I was like 30 years old, That was because that's what I wanted to do.
Gotcha.
I didn't feel comfortable doing it till I was that age.
I think my concern is all the other stuff that you have to take with steroids to do it in a safe way for the sake of your liver, your kidney, your hair.
Exactly.
That's what they don't know about enough. Not every
Exactly.
trainer knows about that other stuff.
Yeah, and I read a lot before I even took. I read books. I was I wanted to do it as safe as possible. I'll just say it like that.
Yeah.
Because I was so afraid to do it.
And there's easily a way that it can go wrong if you don't do it in a safe way.
Yeah, and I don't understand people that don't do it safely.
It's because of the lust for that kind of a body.
Yeah, you got a point there. Yeah, exactly.
Especially when it's
they don't think about what they are doing to their bodies. They just want to be big and muscular. I never had that desire because I was always big and muscular.
Can I take you back to 1995, the first time you did it?
Yeah.
When you did the steroids for the first time, how does it feel? Like, what changes in your body? You're able to absorb more protein and you're able to go harder.
I didn't even think of it like that. I was just thinking of, this is what I got to do to compete.
Gotcha.
Yeah, and I can remember kind of like looking at myself. I'm like, while I was doing it, I didn't see the changes. I didn't see the changes till I got the magazine in my hand. I'm like, whoa, I changed. Because I'm not a mirror person. I don't just get in the mirror and just flex and how I look to myself. And I've never, ever done that. Even to this day, I haven't never looked in the mirror and to see how I look.
As I'm speaking with you, I'm realizing that the football player inside you is very much alive.
Yeah,
and that football, the sports mentality.
And the normal guy is also alive in me because if I'm in the mirror, it's to either do my hair or brush my teeth or something like that. It's never to see how my muscles are.
Okay.
I always relied on other people to tell me how they look, not myself.
How does it feel having that much testosterone in your body?
To me, it's normal. Everything is normal for me, I don't even notice it because I was even stronger before all of that stuff. Remember, I was telling you, I was trying to deadlift 750 and I got it, without steroids and stuff. I was strong. I was deadlifting and squatting 700 pounds without it. I was lifting bench press and stuff like that without it, 400 pounds without it. So to me, it didn't make a big difference. It ain't like one day I was doing 200 pounds and the next day I was doing 400 or 500, everything was always gradual, it was like, now I'm at 500, now I'm at 600, now I'm at 700, now I'm at 800.
Your focus was just the training.
Yeah, it was always just the training, I was never trying to, be real strong. I'll just say it like that. Only time I was trying to be strong is when I was competing in powerlifting for the most part.
Does sex play a role in bodybuilding?
No, I don't think so.
Nothing at all?
No, I don't think so. Matter of fact, I know so. I was just as sexually active without it. If anything, I wasn't sexually active,
But with an increase in testosterone in your bloodstream, do you feel